Welcome to the latest installment of the IJPM Speaker Series. Our guest today is more than just the highest-ranking federal judge in the Syracuse area. She's also a friend of IJPM. She was there from the very first organizational meetings when we were rapidly trying to plan the bench press conference that resulted in the textbook that we use in this course. It was not my experience that you could expect a Second Circuit judge would be at, or any circuit level judge would be at more than just the first meeting to say what she thought other people should do and then depart. Instead, Judge Pooler dug in and helped us with the real work. She was a committee member and didn't put on those judicial errors that we have sometimes heard about from other speakers, not from anybody talking about Judge Pooler. And that was a real pleasure working with somebody who had the experience that she has. I'll just briefly run through Judge Pooler's resume. President Clinton appointed her to the federal district bench here in Syracuse in 1994 and elevated her to the Second Circuit in 1998. And I'm hoping I'm getting my facts straight from our syllabus. Before taking the federal bench, she was on the state Supreme Court bench, also here in Syracuse. And as we all know from our discussions of the judiciary, that is a partisan elected position. She has held numerous positions in legislative, public interest work, government, corporate, and private law practice, including teaching here at the College of Law. Among the positions in her pre-judicial life, member of the State Public Service Commission, staff director of the State Assembly's Committee on Corporations, Authorities, and Commissions. So she has that mix that we have seen in some of our other speakers, but a particular mix of politics and law. She has a bachelor's degree from Brooklyn College and a master's in history from the University of Connecticut, and received her law degree from the University of Michigan Law School. And in a telling anecdote, when Judge Pooler and I were talking about her talk a few days ago, she revealed, and I could tell the way she said it, she was not bragging. She just thought this was normal. To prepare for today's appearance, she read all of the assigned reading for the entire course. And I thought, if it is true that if you want to make it to the top of any given profession, then you can't let anybody else outwork you. And she proves that. She proves that in spades. So we'll all give a warm welcome to Judge Rosemary Pooler.
Mark, thank you very much. Yes, I was anxious. That's why I read everything. I'm delighted to be here because, as Mark so kindly said, I was in on the birth of IJPM, one of the most interesting times. I loved the work, and of course to produce that wonderful book that we're all so proud of, and I'm happy to see some old friends here from the faculty and the students. It's nice to see this lecture series or class become a reality after we were spinning scenarios about, and then we can do this. So it is really a delight. I was scheduled to speak today about judicial ethics. I'm not exactly going to talk about that. And since one of the things I did in my former life when I had a political life was consumer affairs. I wouldn't want to engage in false advertising. So I'll tell you why I have some angst about talking about judicial ethics, and then go on to a topic that I think will be very interesting, especially in the confluence of law, politics, and media, or how law is reported about. So I have some concern about what judges can and should talk about in public. And I spoke to this law school several years ago, and I went back and looked at that talk too, which I saved in my computer, I'm proud to say. And I spoke about my batting average before the Supreme Court. I can't believe I did that because I wouldn't do it today. But I will tell you, just in the nature of reportage, that I had 3 cases before the court this term, which is a very high number considering how many appellate judges there are in this country. And they've already taken one for next term, an opinion that I wrote. So as I said to Keith at lunch, do I have a target on my back or what? You may have seen an article in the New York Times Sunday magazine a few weeks ago with the headline, "When did the Supreme Court become pro-business?" That was written by Professor Gerald Rosen, who I think was part of our bench press. I'm certain about that. And the linchpin of that article was a case called Regal versus Medtronic, in which I wrote a dissent. So when you write a dissent and the Supreme Court takes the case, you say, "Oh wow," but it's not always so good. In any event, it's a case about a balloon catheter that was being inserted into Mr. Regal. It exploded, and he brought a state court action. And the question was, does the Federal Medical Device Act preempt every remaining state action, including negligent manufacture, which is a classic state tort? I thought it did not, based on language in Judge Breyer's earlier opinion. The 11th Circuit thought it did not. The Supreme Court took it and told us that it did. The preemption was practically complete. I'll go on and talk about the other 2 cases in a minute, but one of the assignments for today was Republican Party of Minnesota. And how did they deal with the fact that judges could speak about political issues? I thought, I'll be very interested in what you think, but I thought that Justice Scalia finessed it by saying just because they spoke about an issue, they didn't promise to vote a certain way. And I wonder if you feel that's a complete enough answer, especially with judges who campaign on a platform of harsher sentences or changing reproductive rights. Can you feel that this judge will be open and unbiased and face each question just on the facts before him or her? And that's what leads to my lack of comfort sometimes in speaking about cases. But I had 2 more cases that I'll just tell you about. Just reporting Federal Express versus Holowecki. I wrote the majority opinion. That was affirmed 7-2. It's a nice moment, I have to tell you. And the case stood for the proposition that when the EEOC makes a mistake or doesn't properly call a charging document, the employee who is complaining about discrimination doesn't have to bear the burden of that error. So it was a very nice decision. I suppose nice is not such a bad thing to say. And I have one more case where the briefs are still coming in, called Meacham versus Knowles Atomic Power Plant. And that is an age discrimination case in which I originally wrote the majority opinion, which is much nicer. It was vacated, GVR'd, on the basis of City of Jackson, which I won't go into. And when the 3 of us, the original panel, met, they thought the outcome was determined. I thought we still have the right answer. And the Supreme Court, this is so nice, when the Supreme Court will let me know before too long which of us, either the 2 on the majority or I, understood what they were saying. It's very satisfying. You know, you want every book to end. You want to know how it comes out. So I'm looking forward to that. And I have to tell you, I know that many of my colleagues don't share my view about what they could talk about. After Regal was taken by the Supreme Court, I told some of you at lunch, I got an invitation to speak before a group of litigators a group called the ACC. I forget what it stands for, but it wasn't secret. And they seemed like a very fine and responsible group that contained both plaintiffs' bar and corporate defense bar. Government people spoke to them. And they asked me to be, after I wrote the dissent in Regal, on a panel called Drug and Medical Devices. Well, and I thought, well, what do they want me to read my dissent? Do they want me to say things I didn't put in the opinion? Because I think that's entirely inappropriate. Should I give a gloss on my opinion that would be cited back to me sometime? Or worse, if I went and talked about the dissent in words, not just in writing, what would happen the next time I got a medical device case or a preemption case? Preemption cases we have all the time, not so many medical device cases. It is the very issue in Republican Party of Minnesota. A recusal, I don't know. I would be very concerned if someone said, you've made up your mind on this, Judge Pooler. I don't think we can trust you to look at this issue again. We know how you feel about preemption, and we know that you feel that state tort claim causes of action will survive the Federal Medical Device Act. I'd rather just not put myself into that position. That's why I give you this long peroration. So this institute was founded to study the intersection of law, politics, and media, and I find that endlessly fascinating, even if I don't want to speak about it so much in public. I have a certain amount of discomfort, but I am a human being, and as Mark said, I had a political life before I came to the bench, and I'm interested in what other people think. I'm certainly interested in reporting on decisions, which I confessed at lunch I check on a blog, and I read the newspaper of record. I'm very interested in that. But I have to tell you that I am personally offended when I am or one of my colleagues is identified by the name of the president who appointed one of us, assuming that we are merely predictable automatons. And yet I know of some scholarly research that you may have come across this semester, which seems to suggest that if you know which president appointed a judge, you may be in a better position to predict outcomes than someone who knows nothing about that judge. I'm not going to comment on that. Maybe we can talk about that later. I see the analytical model for this course is one that says judges don't stop being political persons when they become judges. And as Mark rightly said, I was an elected judge. And yet now, from the vantage point of the federal system, I cringe about judges raising money for elections, something that I had to do. It is incredibly troubling how much money is spent on elections, and I was saved from having to run for re-election by President Clinton, but I would have had to run for re-election to the state Supreme Court judgeship to which I was elected. Money has to be raised from people who care, and that turns out to be the bar, and that is very troubling. I know you've read some of the stories that have been in the press over the past several months and years, and yet I think elections are valuable because I know you're going to read Taurus next week if you haven't peeked ahead on that very interesting case. I was nominated at a nominating convention, so I felt pretty ambivalent about that case, and I finally concluded that the nominating conventions are not as bad, I'm not going to say constitutional or not, when it is a minority party, not a majority party, that is nominating. Because ordinarily, those nominations are not worth much. and so they can afford to be democratically legitimate because so little is at stake. I was fortunate to have a minority party nomination and to be in a very lucky position with the stars aligned and to get elected. So I thought the system worked very well to bring in people who otherwise would not have been able to be elected to the Supreme Court in the 5th Judicial District, which comprises 6 counties in upstate New York, of which Onondaga is the biggest. So for me, it was a wonderful opportunity. It's hard to then say the whole system doesn't work, which fortunately I didn't have to. I wasn't on that case. And because of my history, I might very well have recused myself on Lopez Torres because it was my life. So with all this as intro, I want to talk about sentencing because our courts are really being roiled by the changes in sentencing precipitated by the decisions of the last several years. And I think sentencing is very interested from the point of view of politics, and sentencing is what's reported by the press. You may not be able to grasp a reporter, and of course, Linda Greenhouse is the ideal. She can report on subtle and nuanced issues before the Supreme Court. But finally, not everyone is going to want to read, 20 column inches on a Supreme Court case. But everyone is interested in how criminals are sentenced, especially as we've seen in the last several years, white-collar criminals. Some very long sentences for people who we would think traditionally would not have spent the rest of their life in prison. So judges take this very seriously. And I'm going to begin with a very short primer on federal sentencing, very short. Prior to the adoption of the guidelines, I brought my newest copy. They were adopted first in 1986. And it surprises me that it's only 20 years ago, and that it's also been 20 years, because it is a world of change. And I have one statistic that is quite stunning about what the guidelines have accomplished. So I've been told by judges who are on the bench before 1986, some of my older colleagues, that the pre-86 years were the golden age of judicial discretion. They thought they could do the right thing as they were required to, and they thought they could take account of all the factors that were required to sentence a convicted offender. Of course, there were statutory maximums even then, tied to drug laws, gun laws, fraud, traditional state crimes, robbery, burglary. And the state laws were always available as apt comparators, so that even when there weren't federal guidelines, state judges, federal judges would tell me, we would see what this criminal would get if he or she had been prosecuted and convicted in state law instead of federal law. And that was always a good check on rationality. That's what I've been told. It does predate my time on the bench. But even with those comparators, a federal judge appointed by the president and confirmed by the Senate for life could take into account factors that might not be obvious. This is a judge who may have sat through a trial, a judge who may have read 50 letters about the good deeds that the offender had participated in. The most immediate things that any judge would take into account, even before the guidelines, was what was this person convicted of, as we say in a sort of mellifluous term, the offense of conviction, and the seriousness of that offense, the victims and the effect on them, and the effect on the community, and information about the defendant, for example, her criminal history. Was this her 10th attempt to defraud elderly persons committed to her care, or was it her first? That makes a difference. So those of you who are history majors, as I was outed about during the introduction, will know that incarceration developed in this country as an alternative to the ultimate penalty, which was always death for felons of all sort. And it was very progressive to have incarceration as an alternative. And over the 2 or 2.5 centuries of our country, we have gone back and forth through many regimes. Rehabilitation, separation from the community, isolation, education. And if you think this is not current, I don't know if any of you saw yesterday's Times writing about a bill that the president is about to sign, I think passed by both houses, I'm sure, if he's about to sign it. It was called A Second Chance, which talks about the new buzzword, which is called reentry. So that if we want convicted offenders to have a chance at re-entering society, we have to think about education, we have to think about giving them a record that will still allow them to find employment. We have to think about bringing them up to where they would have done. That's the chance. That's the second chance. I don't think repeat offenders will benefit from this bill, but first-time offenders, especially young first-time offenders, maybe will have a chance not to spend the rest of their days in prison. So while the last quarter of the last century may have been the golden age of discretion, complaints arose from 2 separate quarters. From reformers who complained about unpredictability and harshness of sentences. This was all precipitated by a book by Marvin Frankel about sentence disparity. I wish I had the name of it right here in my notes, but I don't. And the other quarter from which complaints arose was from those conservatives who complained of the coddling of criminals. So that because of disparity, regional differences, and congressional reaction to the extension of constitutional protections to the accused, and I speak of the Warren Court, you know the cases, Miranda, Mapp, because of that confluence, both liberals and conservatives, and I'm not putting a specific definition on those, wanted to change the system of unfettered discretion. So the coalition of reformers and those who viewed judges as soft on crime came together to create the sentencing guidelines after Congress passed the bill creating the Sentencing Commission. The chief staff person, as you may know, in writing the guidelines was now Justice Stephen Breyer, who was staff to Senator Kennedy on the Judiciary Committee at the time. So the guidelines, for those of you who have never had occasion to work with them or even have seen them, arranges everything you need to know on 2 axes. And I'm going to show it to you in a moment. I'll show you the sentencing table. Proceeding down the left side of a single page are the offense levels from 1 to 43. From 1 to 12, the offenses are in so-called zones A, B, and C. You don't have to know this. I just tell you that because that determines whether an offender is eligible for a non-incarceration sentence. And from 13 to 43, all are Zone D, and those must be incarcerated. No discretion about that. Across the top of the same single page are criminal history categories from Roman numeral 1 to Roman numeral 6. At the point where the 2 axes intersect, there is a range expressed in months. So I will just show you what it looks like, the sentencing table. So if you've never seen it, the offense down here, criminal history category here, and once you find the offense, you look across for the criminal history, and you find a range expressed in months, say 41 to 51. How much is that in years? Until I learned the 12 table again, I was out of luck. At the top, that's 4 years and 3 months. It seems more benign to talk about months, but it's good to remember that we think in terms of years, not months, when we think of sentences. So I want you to think for a moment, the reason I bring this is to think about the optimism of the drafters who believed that they could capture all information needed about offenses and offenders on a table and in a book. Offenses were described and roughly points added and occasionally subtracted based on more specific aspects of the conduct. So, for example, if you defraud a bank and you work in the bank, you are abusing a position of trust. If you don't work at the bank or you have no position of trust, you wouldn't get that enhancement. Or if you're involved in a crime involving fraud, in here is the famous fraud table, which adds points depending on the amount of money involved in the scheme. And if you know that, you will understand why some of the white-collar convicted offenders got such long prison sentences. And of course, the federal system does not have parole, so you serve 7/8 of the full sentence, provided that you get that 1/8 reduction for good time, and that's all. That's all. So after the first number, where you find where the axes intersect, certain adjustments are made. Vulnerable victims, you get more points. Other things that pornography involving children, it's different if you look at it or if you make it, or if you distribute it or you traffic in it. Each one of those is a different penalty. But 2 adjustments in particular formed the basis of much of my life in the years between the enactment and the decision in 2005, which we refer to as Booker. I don't want to get ahead of my story. So these 2 adjustments were obstruction of justice, which would ordinarily add 2 points, and the district judge could allocate up to 4 points for minimal, minor, and major role in the offense. And I want you to think drug conspiracies and consider street dealers versus drug kingpins. And you also have to know that the thing about drugs is the amount of drugs counts a lot. So if you are a street dealer, but you're part of a drug conspiracy, all the drugs that the gang distributes can be attributed to the lowest guy on the ladder. And it becomes even more excruciating because the lowest guy on the ladder usually has nothing to trade with the prosecutors. He is the lowest guy. But the guys at the top have a lot to trade. They know where the drugs come from, because typically they were the ones that purchased the drugs and then distributed them in a pyramid. So we saw many examples of the people at the top of the pyramid trading information to the government and the people at the bottom who were really street sellers who were like retailers. they would get a small amount of drugs for X dollars, and if they weren't users, they would sell it for X plus $1. They were not getting rich, and they were the most vulnerable, and they didn't have generally good lawyers. So that became one of the problems with the guidelines, that they couldn't capture this fact pattern that I just described. Criminal history, the line across the top, has its own problems. All past offenses, almost all counted, unless they were very, very long ago. And only recently we have our circuit, and every other circuit, has looked at the issue of youthful offender convictions. And think about that when we talk about a second chance. You would think that a youthful offender conviction, which promises the offender that if you don't get into trouble again, this record will be sealed. You will not have to tell an employer from whom you're seeking a job about it, and no one will be able to get it by subpoena. That's what we tell youthful offenders. And yet, they turn out to count in arriving at a criminal history. So that someone who gets the benefit of all this treatment still will not necessarily be in the lowest category because of youthful offender convictions. And then the last part of how we arrived at this magic number that I want to mention is something called departures, both upward and downward from the yielded range at the intersection. The most typical basis of departure is cooperation with the government. That's what I was describing, the guy at the top, for substantial assistance. And it's appropriate. The government needs information, and if someone will give them information about a conspiracy, and in so doing, the government can then roll up an entire drug distribution ring, it is worth it to give a shorter sentence to someone. But think who knows most about the conspiracy. So other grounds for departure were few and far between. Many judges did a lot of creative work in trying to find departures, family situations, age, background, good works, all sorts of things. Most of them were rejected by appellate courts. And that is because the guidelines were mandatory. So notwithstanding the departure authority that sentencing judges possessed, a non-guideline sentence was a target for an appeal. There were very few successful appeals of upward departures because a judge's recitation of her view of how the guideline range understated the seriousness of the offense and the effect on the community was hard, if not impossible, to controvert. And while very large and public downward departures were appealed, most were not, both because of the allocation of scarce prosecutorial resources and because, like any good litigator, the U.S. attorney had to worry about making bad law. So we didn't see a lot of downward departures. And now I want to give you that statistic that I mentioned. And this is from a paper that Jack Weinstein, a district judge in the Eastern District of New York in our circuit, wrote about sentencing. And he was, and is, one of the most creative of the judges. And this is from a paper he wrote. Quote, "Besides the less tangible effects on judges, attorneys, and defendants of such spiritually numbing arithmetical exercises, the guidelines had an immediate effect on sentence length. Before the guidelines took effect, the average federal sentence was 13 months. After, it was 43 months. Whereas half of all defendants were sentenced to probation before the guidelines, only 15% received probation afterwards. So cataloging, writing it down, requiring judges to go through this exercise had an immediate effect of more sentences, more and longer sentences, more people incarcerated, as we know. So I sentenced under the guidelines because I was a trial judge in the federal system. And I believed in those years that I was constrained by the laws that I was sworn to uphold. I want to tell you a story about one of my very first sentencings. Now, you all know that criminals, in order to be convicted, the accused has to be convicted of every element of the offense, and every element has to be proven beyond a reasonable doubt. This is the first day of law school. We all know that. Every element of every offense beyond a reasonable doubt. And the jury is told that, and the jury has to find that. So I discovered at my first sentencing that there were other things that I could decide by a preponderance of the evidence. By a preponderance of the evidence. So if someone was convicted of possessing with intent to distribute 10 grams of a drug, I could attribute to that person 100 other grams, substitute any numbers. And I could do that based on preponderance of the evidence, and I could do it, as I did, based on double hearsay. So the first time I was told this by a law clerk, I said, this can't be right. And she said, it is right. And I said, it can't be right. And so, in any event, she was right, because that's what our circuit had said. I'm pleased to tell you that's no longer right. And in my bones, I knew at the time, although I was following the law as it existed, that it wasn't right. So the scheme of the sentencing guidelines was enacted by delegation of Congress, as I mentioned, to the Sentencing Commission. So that is, when Congress enacts something, that is the people speaking. It has the most authority that we can imagine in a democratic society. But I have to tell you, as a judge, as a sentencing judge, I always felt that the people were stunned by the length of federal sentences. So I heard people gasp in a courtroom. That was in the very beginning. After a while they understood it. But the sentences are very long. So one of the adjustments that you could make to this number was to allow a deduction of 2 or 3 points for acceptance of responsibility, where the defendant says, I did it, I'm sorry, I know I did it. That is, not go to trial and plead guilty to get that reduction. It's almost never available to defendants who take their cases to trial, except if they are challenging the constitutionality of a law under which they're being tried. So, since prosecutorial discretion allows the government to decide which cases to take to trial, it is rare, but certainly not impossible, for the government to lose. So with that knowledge, the best criminal lawyers, in my experience, started negotiating for a sentence rather than anything else, rather than worrying about a trial strategy, rather than worrying about alibi witnesses. They were negotiating as to what offense their client would be indicted and convicted or plead guilty to. That was the state of sentencing when I first got to the federal system. So after the enactment of the guidelines, the discretion of which certain judges remember so nostalgically, that discretion was transferred, many judges and scholars believe, to the prosecutors, who could decide on the fraud table how much to charge you with getting illegally, could decide how many kilograms or ounces of drugs with which to charge you. Since every offense was given a number value, and many times particular offenses could fit more than one category, it was the prosecutor who, more than anyone else, had a role in determining the sentence if the guidelines were mandatory. That is, the prosecutor would decide, this is what I'm indicting you for. I am attributing this amount of drugs to you, and you knew if that person was convicted, the trial sentencing judge had to follow the guidelines. So that was the state of affairs. The first challenge to the guidelines claimed that they were the product of unconstitutional delegation by Congress to the Sentencing Commission. Over a strong dissent by Justice Scalia, the Supreme Court rejected this challenge. A tension in the system, quite apart from the mandatoriness, arose from appellate courts becoming the enforcers of the guidelines. Before the enactment of the guidelines, appellate review was normally confined to the conviction or the management of the trial. Did you make a mistake in letting evidence in that you shouldn't? And rarely touched upon the sentence, so that you would attack the very conviction. So this was another feature of the guidelines that was at first only noticed by judges, that we started getting sentencing appeals. And what followed after that was several years of trial judges astonished at the loss of their ability to sentence as they saw fit, who said on transcripts, "I wish I didn't have to do this, but I don't have a choice." That's what judges would say to the person who was standing right in front of them that they were sentencing. "I wish I didn't have to do this. I think you deserve a break, but I can't give you a break because I have to sentence you to this," or similar statements reflecting the mandatoriness. Appellate courts then developed a body of law that explained to sentencing judges that they did have departure authority. We said further, and this is all the circuits, this was uniform, that no sentence could be reversed for failure to depart unless the judge thought he couldn't depart. So then we entered several years when judges said, "I know I can depart, but I don't think this case merits a departure." And what I'm doing is summarizing hundreds of cases. So those cases were pretty much affirmed unless the judge said something that a good defense lawyer could convincingly argue bespoke an inability rather than an unwillingness to depart. So at some point, district judges learned what to say or said nothing. That was when we developed a body of case law saying we do not require robotic incantations. So we don't require a judge to say, "I know I can depart, and I've read the guidelines." We don't require that. We assume that judges who are doing this for a while know what they're doing and understand their authority. So that was 10 years. That was the first 10 years of the guidelines. In 1996, the Supreme Court spoke again in a case that we all called Kuhn, but Kuhn was only one of the defendants. The name of the case is Powell. Sergeant Kuhn was one of the officers charged with depriving Rodney King of his civil rights in the federal case after those officers were acquitted in the state criminal trial. And I'll tell you why I remember this well, because I was a district judge at the time. And the case stood for the principle that district judges, that is sentencing judges, were in the best position to fashion a sentence because they were in the courtroom with the defendant. And appellate judges must not review sentences de novo, that means from scratch for those of you who may not be law students, but according fact-finding by district judges, abuse of discretion review, and only reviewing conclusions of law de novo. This is much more discretion than they had, than district judges believed they had at this time. And the reason I remember this so clearly is because this case came down when I was at a judicial conference. So I was a federal judge for just 2 years, a real child at the time. And an appellate judge came over to me at this judicial conference and said, "You guys won this one." Huh. So I didn't even know we were in a contest. I didn't appreciate the tug of war between both levels of judges competing for whatever discretion was left to federal judges. I didn't understand that. And Sergeant Kuhn, who was convicted, was given a shorter sentence because the trial judge felt that police officers have a tougher time in jail than non-police officers. And that was a basis. And I have to tell you, this is not one of the factors in this gigantic book. They thought they could list everything in the world you'd ever want to know, and they never thought to list that. And the trial judge used it as a basis for a lower sentence, and that was affirmed by the Supreme Court. So that began a real new world in sentencing. So there's that tension between trial judges and appellate judges, and part of a larger struggle by members of the Supreme Court who still believed the guidelines themselves were constitutionally defective. I'm now coming to the third act, because this is truly the most exciting part. The first shot across the bow came in a case called Apprendi versus New Jersey. These cases are so well known that if you go into Google and just write Apprendi, you don't have to go into Westlaw. You don't have to go into a blog of law review articles. Go into Google and you put in Apprendi, and you find out that in that case, a sentence imposed after a conviction for a garden variety shoot a gun into your neighbor's house, I know it's not garden variety, was enhanced because the neighbor was African American and New Jersey had enacted a hate crime law, enhanced by the judge. The Supreme Court now had the ultimate rationale with which to consider the guidelines, the Sixth Amendment right to a jury trial. Apprendi says that any enhancement, like the amount of money involved in a fraud offense, like the amount of drugs you are charged with, must be found by a jury or pled to, that is admitted, if it increases the sentence beyond the statutory maximum. So this was really all about drugs. The jury wasn't expected to know how many drugs were part of the conspiracy. All they know is that they found a kilogram of drugs, and yet they were being charged with 150 kilograms. Well, who was going to add those 149? The judge. Those days were over. After. They weren't immediately over. They were like someone who has a fatal disease but doesn't know it yet. But after Apprendi, think about it, they were doomed. And Congress is very, I'm embarrassed to say that's probably my phone, but maybe not. I forgot to turn it off, but no, someone else could be embarrassed. So Congress and drugs has been very interesting. Congress has spoken loud and clear because they really, that's what they can do. They can sentence, they can increase mandatory minimums. Drug offenses were to be punished harshly, especially some drugs, and especially some amounts. It was here that the 100-to-1 crack to powder cocaine comes from. It was Congress that believed, the Sentencing Commission is their delegate, that crack was more dangerous to communities because it was cheaper, and it had the effect of putting many more African Americans in prison, as you now know. But it wasn't just Congress. The state analog in this state were the so-called Rockefeller drug laws, which put people in jail for 20 years for possessing a small amount, even of marijuana. I'm not talking about heroin and cocaine. So our federal and state legislatures spent decades concluding that the way to win the war on drugs was to enact ever harsher penalties for ever smaller amounts of some drugs. And I express no opinion on this except to say that those laws are now being changed in both states and in the federal system. And if we want to discuss cocaine crack afterwards, I'll be happy to discuss that. So after Apprendi, bringing back to our story, the Supreme Court turned in June 2004 to a state of Washington sentencing scheme that was identical to the guidelines in all important features. The name of the case is Blakely versus Washington. That is, there was no principled distinction. So when I say someone has a fatal disease, this was another MRI. The charge against Mr. Blakely was that he had kidnapped his estranged wife. The facts admitted in the plea, standing alone, supported a maximum sentence of 53 months. But the judge imposed a 90-month sentence after finding that the petitioner, before the Supreme Court, had acted with deliberate cruelty, a statutorily enacted ground for departing from the sentencing range. Blakely was reversed by the Supreme Court based on Apprendi and based on the right to a jury trial, the right to have a jury decide every element of every offense upon which you will be sentenced. Well, so then it was just a matter of time after Blakely, many of us felt. That was what I called the Blakely summer. It came out in June, and I had two interns who were first-year law students. They knew nothing. And the worst thing is they didn't even know they knew nothing. So I was really being nice to them, and I gave them sentencing cases to work on for a July sitting. And Blakely came down in June, and we understood in our circuit that it was a changed environment. And then it was only a matter of time until January 2005 where the two Booker cases came down. There were two opinions. There was the so-called substantive opinion written by Justice Stevens, and joining that opinion were what was viewed as the more conservative four Justices Thomas and Scalia. And I think it must be O'Connor and Kennedy, but I'm not certain. The only judge who was on both opinions was Justice Ginsburg. So in Booker, the jury verdict would have allowed the judge to sentence Mr. Booker to a range of 210 to 262 months. You don't have to know your 12 tables, but just know that 240 months is 20 years. So you could see where you are. At sentence, the judge did just what I did. He found additional facts by a preponderance of the evidence and gave Mr. Booker, based on the additional drugs attributed to him, 360 months, which now we know is 30 years. The Seventh Circuit, relying on Apprendi, reversed, and the Supreme Court affirmed the Seventh Circuit. So the mandatoriness was now, the fatal illness was now acknowledged. In Justice Stevens' opinion, they made patent that federal sentencing can only be based on, a sentence can only be based on facts found by a jury or admitted to by the defendant. But that's only half this wonderful story. There was another Booker opinion, and it was written by, I love circularity, don't you, where you wind up almost where you begin. It was written by Justice Breyer, who was the original drafter of the guidelines, and it was called the remedial opinion. And what the remedial opinion did was excise the section of the guidelines that made them mandatory and treated them only as advisory. That's how they were saved. Justice Ginsburg made the 5-person majority in each case. So there's just a little epilogue. I know that was Act 3, and it's so dramatic. I wonder if any of you can imagine. This was our life. I was doing sentencing cases. I was reading this opinion. I happened to be on vacation, because I live in Syracuse. So January is when you want to get away. And I was reading this in a vacation place. And I kept saying to myself, I can't believe this. Anyway, so I have such an image of myself doing that. Post-Booker, our circuit sent back any sentence that was still on direct appeal or anyone who had preserved a claim that the guidelines shouldn't be mandatory. You have to be a really smart lawyer. This is 2005. They were passed in 1986, and yet some lawyers continued to press. Maybe they didn't do full dress argument, but they preserved them in their briefs that the guidelines were a deprivation of the defendant's Sixth Amendment rights to have every element of every offense found by a jury. And they preserved it. They kept putting it in their briefs. You got to love that, right? And so those people who preserved got resentencing. They had good lawyers. And those people on direct appeal, we called that, it was in a case called Crosby that we decided, Crosby remands. And they went back, and the judge had to decide whether a non-trivial difference would ensue if he or she knew that the guidelines were not mandatory. In truth, that's not where the changes came. Most judges said that it wouldn't be, that they would probably sentence the same way, but it changed the future dramatically by making them non-mandatory. In the 3 years between Booker and my very last thing I want to talk about, really a triad of cases, but one petitioner inconveniently died while the case was pending, so they had to wait for another petitioner to come along. 2 more cases came down in December of last year. Kimbrough and Gall are the names of the petitioners. Derek Kimbrough became sentenced on the 100-to-1 crack ratio, and his lawyer appealed. What's the basis of this? He took all the way to the Supreme Court. And Brian Gall, Carla was there. I called the judge who decided Gall, who was a friend of mine. And after I spent time thinking about these cases and writing this talk, I really wanted to know what possessed him to have the internal fortitude, because he sentenced Brian Gall below the guidelines. Brian Gall was a University of Iowa student who got involved in a drug conspiracy. It may have been ecstasy. I'm not sure what the drug was. And at some point said, I'm ruining my life, and he left the conspiracy, which you can do, but you can't just say it to yourself. You have to tell everyone that you're leaving, and there has to be evidence of it. He left the conspiracy, rehabilitated himself, graduated from college, went on to do good things, have a good job. But the government had his name, and they went to prosecute him with all the other members of this drug conspiracy. He pleads, and he comes before Judge Pratt in Iowa, who looks at the offense, looks at the fact that he left the conspiracy, and looks at what he's done with his life post-membership in this, and sentences him to 0 incarceration time. So what I wanted to ask Judge Pratt was, where do you come off doing this when we have been living with this scheme? And he told me 2 things. One, he told me that he was reversed 9 times before Gaul because he was doing this, and it found no sympathetic audience in his circuit, which is the Eighth Circuit, who took to believing, even after Apprendi, Blakely, and Booker, that as long as you were within the guideline range, you were probably reasonable, and if you were outside the formally mandatory guideline range, you probably were not imposing a reasonable sentence. So this is a great story because judges love this more than anything else. He sentences Gaul to no incarceration. He is reversed by the Eighth Circuit because it wasn't reasonable, and the Eighth Circuit is reversed by the Supreme Court. So that's what the phrase, how sweet it is, was invented for, the day you find that out. And the language in Kimbrough and Gaul is quite wonderful. It says, you didn't get it these other couple of times. Judges really do have discretion. The further they go from the formally mandatory range, the more they have to explain. But that's all. So if the sentence was originally, as I pointed to, 41 to 51 months, and a judge thinking seriously about the factors that you still have to consider, I'll read them to you. They are the factors that any judge has to consider: the nature and circumstances of the offense and the history and characteristics of the defendant, the need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, the need for the sentence imposed to afford adequate deterrence to criminal conduct, and to protect the public from further crimes of the defendant, and to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. So we know this is not exactly science, right? These are what a judge has to consider, and if a judge is willing to do the work that's necessary to persuade her reviewing court and ultimately the Supreme Court that they have considered these somewhat elusive factors, and they have concluded that the interests of all the stakeholders, the public, the community, the victim, the offender, that the interests of all of them would be best served by a non-incarceratory sentence, I believe we have entered the age where a judge can accomplish that. And that is really revolutionary. Just to bring this to a close and leave some time, have we seen a lot of reportage about this? Not so much. It's a revolution in my life, but I don't know that the general public has been following this. You have to read the Times, and you have to read it regularly to follow this. Lawyers know about it. The defense bar knows about it, and I can assure you the U.S. attorneys know about it. Politics. What does this mean? What does it mean when now we will have confirmations post Kimbrough and Gaul? Can judges be expected, federal judges be expected to be asked, are you ever going to sentence a violent criminal to non-incarceratory blah, 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 blah? I don't know. I don't know if you'd answer it. I don't know if you'd say I hadn't thought about it. It would depend on the factors. Maybe you could memorize the factors and say, this is what I would rely on. The issues are very verdant, and they are there, and that's what I bring you to think about at the confluence of these disciplines, a whole new world in sentencing. Thank you. Thank you. I think I spoke longer than I was supposed to, but I couldn't stop before the third act. I guess we have some time for questions until 4 o'clock. Questions, anyone? Keith.
I was wondering if you had a sense about how the image of the judge might have changed while the sentencing guidelines were mandatory? I mean, you said beforehand what gave rise to them were these powerfully felt, although contradictory, conceptions. On the one hand, judges are coddling criminals, they're soft on crime. On the other hand, they're tyrants or sort of throwing people in jail, locking them in jail, throwing away the key. And so you had this kind of coalition coming together for the sentencing guidelines. Do you think that there was that had an effect once they were in place on the public perception of judges? Or do you think those popular images just kind of stayed out there, even though judges were now constrained by the guidelines?
What's interesting to me is that there are regional differences, which I think explains a lot of what seems like contradictory images. Judges, after all, are nominated from the region that they're going to serve, and state judges are either elected or appointed from even a smaller area. So I think that there was some feeling that some crimes were punished more harshly in other parts of the country than the part where we're standing, and that's what reformers worried about: disparity. That if you had a house invasion in say Mississippi, you would be punished differently than if you had a house invasion in the Northeast. I'm theorizing. So that judges may have had different images in the community, and they may have been responding to what the community wanted. Some communities want harsher or stronger law enforcement. I think harsh is too value-laden. They want criminals to pay the price for their crimes. But I think generally, and of course I wasn't perceptive enough to be watching at the time, that some judges had very kindly reputations in the pre-sentencing era as those who tried to serve the community, vindicate the victim's rights, but also not lock someone up and throw away the key. And I think during the years, those 10 years of the guidelines, my impression is that, as Judge Weinstein said, they seemed much more like accountants than people who were bringing to bear a real intelligence on the task of figuring out the right sentence.
So they seemed that way. I mean, they felt that way administratively.
And I think that
publicly perceived that way.
Yeah, except I think this is really below the radar of much of the public. By this time, I've been involved. I think lawyers would have had this, and there were a lot of people writing about penology and sentencing, and there are 2 million people incarcerated in this country. That's a statistic that just came out this summer, and I think it's very salient when you find out that it's more than, I think, in larger, more populous countries. We have more people incarcerated, and people wonder, how did we get to that state of affairs? But I don't know. The best thing is that most people don't have any contact with the criminal justice system, and so they don't have an impression of judges except from Law and Order, where they're always grouchy but fair. So I just don't know. I don't know what ordinary people think. So I'm really talking much more of an insider. I wonder what other people think. Yes?
Do you think there is a right sentence? I mean, when you get a case, do you think in your own mind there's a right sentence, and whether the guidelines fall within that or not? I mean, is there kind of a natural law right sentence for any particular crime?
I don't know right, because that seems like, a platonic ideal. But I think if you want to sentence someone enough so that a lesson is learned, but not more than that, that's another section called the parsimony section of the guidelines. I think it might be lower than the formally mandatory ranges, which turned out to be very long because they were blunt instruments rather than scalpels. Right sentence, I don't know. I don't know. We're supposed to try and stop recidivism, and it's been shocking to find out that no scheme has has done that for certain crimes and for certain individuals. But I think there are lighter sentences than what used to be a straitjacket of categorizing offenses. I think this new world will lead to better, more useful sentences, and I mean useful from the societal point of view. I do. It's hard. It's a very hard thing to do. Deprivation of someone's freedom.
I think a lot of people who favor sentencing guidelines or lessening judicial discretion tend to argue that judges simply aren't in the position from a criminal justice point of view to really know the effect of lessening greater sentences as opposed to prosecutors or the legislature. And so when I heard from your talk that you see judges kind of blunting the force of the prosecution as kind of a lessening sentence, as a role of lessening harsh sentences. And I just wondered how, your perspective, is it a constitutional reason do you think judges need to be involved or fairness?
Judges, no one can be sentenced to a crime for which they haven't been convicted or admitted to. So that's the first thing. So immediately, if they plead, they're in a negotiation mode and can get something in return, a lower range. Even though it's not mandatory, the range still has to be calculated, by the way, even in this new regime. Has to be calculated, but then it doesn't have to be complied with. And I think I wouldn't underestimate judges who've been doing this for a long time and their understanding of the effect of incarceration on communities and on individuals and on victims, on the victims of the offense. Prosecutors are advocates in a system. That's how we want it. We think the adversary system produces the best results. It's the foundation of everything that we as lawyers do. So the prosecutor is the advocate for punishment for the victim. The defense counsel speaks for whatever sympathy or whatever grounds can be mustered for a shorter sentence, and the judge, who should have wisdom and experience, reaches the right sentence, I think. I don't think they blunt the effect. The prosecutors who are in court day after day are very respected by most of the federal judges. After all, U.S. attorneys are usually very distinguished in the community and well-known and very experienced. So I don't think their advice is tossed out. It just goes into the overall consideration. The worst thing is when they're a bad defense counsel, because then there isn't a counterpoint to the usually sophisticated arguments made by the U.S. attorney. I don't know how you improve that, but that's a very serious problem in representing defendants, especially indigent defendants. Yes?
What was the state response to the federal sentencing guidelines saga? Did states follow suit?
Yes, most of them did. Most of them did, and that's why the Blakely decision was so useful, because they had copied, in all important respects, the federal system. So when that was found unconstitutional in the state of Washington's system, it was only a matter of time before that majority also found the guidelines unconstitutional. Leslie.
How are you?
Oh, good. How are you? Good, Professor Bender.
Thank you. I was wondering if you know if anybody's done follow-up studies post-Kimberly Gold to see if prosecutors are charging higher offenses to get bigger sentences, or if the sentences are significantly different since those decisions.
I don't know yet. It's too new. They came down December 10th. And I haven't seen the cases yet. But I do know that all of DOJ conferred they brought U.S. attorneys from all over the country to decide just those things. Do they charge a higher amount of drugs? Do they not make bad law? Do they negotiate from a tougher position? I don't know that yet. If anyone will have that data, it will be the Sentencing Commission, but they're usually a year behind. But that is among the most interesting cluster of questions. What does this mean? What does it mean? I don't know yet, but I commend it to all of you to follow this as it develops. This is really new, December. We haven't decided our response yet as a circuit. Anyone else?
Judge, you mentioned the relative lack of attention that the media have given this policy and legal debate. But one thing that we can always count on reporters to do when covering federal criminal cases, or any kind of criminal cases, is to characterize a defendant's exposure in terms of the maximum sentence. So she faces up to 3 lifetimes in prison.
Right.
They always stack everything, and it's the maximum.
Right.
And the operative phrase is up to, and theoretically possible, but not really true.
So that any sentence looks soft when they get it.
Well, that's one effect, and what I'm wondering is, I've always wondered how accessible are the guidelines, non-mandatory though they are now. How easy would it be for a layperson to crack open that book and figure out what might this person face in reality?
I think anyone who can read, at an 8th grade level, I'm really not kidding. I'll open just to a page and I'll look. The largest chapter, the largest section is Section 2, because that has all the offense. So I open here to the use of 2K 2.4. We get used to talking like that. And the section is the use of firearms, armor-piercing ammunition, or explosive during or in relation to certain crimes. And what that means is if you're already robbing a bank and you have armor-piercing ammunition, you get an enhancement for that. So that seems pretty clear, and it says if the defendant, whether or not convicted of another crime, so say they can't convict you on the bank robbery because they didn't have enough evidence, was convicted of another section, the guideline sentences the term of imprisonment required by statute. Chapter 3 and 4 shall not have... Yeah, I guess it is a little going back and forth. Let me see if I can find some meat of this. It really does. So the answer is, I think you would need a little background, but I don't think you would need a law degree. And in fact, all the recommendations made by our probation department, I don't know if any of you know this, but judges are given a recommendation, and this is by someone who reports to the judge. The prosecutor has a recommendation, the defense attorney has a recommendation, the judge gets a neutral recommendation from a probation department, and those people are not lawyers. They're trained in the guidelines. I think they are accessible, and I think they would be very interesting. And I'll tell you something else. I've seen a lot of criminals who actually, certainly if it's more than a first conviction, who understand the guidelines and their interplay. They do. This is for an average intelligent person, and if it isn't, it would be a failing of democracy, not of the guidelines. This is really important that people understand this. Yes.
Oh, and Judge Pooler, you mentioned earlier about sort of your concern, I guess sort of your new perspective that you're concerned with regards to the election of judges. I'm thinking this is probably an issue that could also raise some concern, because you could have a situation where, as the public, the voting public, is pulled one way or the other in terms of who to vote for a judge. Could you see this being an issue where a judge says, I'm for strong sentencing guidelines versus weak sentencing guidelines?
Certainly in Minnesota.
Oh, exactly.
I don't know. When I ran for office, I had memorized the following sentence. I would go to a group, usually a bar association, and say, I'm sorry to tell you that any issue about which you might even be remotely interested is the very issue about which I can't comment. And because I wasn't going to answer a question like that then or now, and I don't think really a judge should or could. But you're right, nothing will stop the public from trying to get an answer. And I have seen television commercials for judges who use all those code words, law and order, which is, good words, law, order. We don't want non-law and disorder, but used in ways that signify a certain interest in putting away criminals for a long time. And I don't know where I think the public has understood what it's cost us as a society in terms of taxes. I mean, we spend a lot on prisons. And this piece in yesterday's Times says that they understand that we're wasting lives if we don't give first offenders, a second chance. So I don't think it's entirely clear that the general public would necessarily immediately choose harsher sentences if they had a really clear discussion of the alternatives. Politics doesn't always do that, a clear discussion of the alternatives, right? I mean, we know that. So you're reduced to bits of information. That's hard.
I believe we've run out of time for the public portion of this. I want to thank Judge
Thank you very much. Thank you for your attention. Thank you.
Please join us for the reception outside. And